Jackie Hudkins with Hudkins Law, here together with my colleague and business partner, attorney Candice O'Neil. We're both licensed in New Hampshire and Massachusetts, where we have active practices across 6 offices. And we'd like to talk with you about an emerging trend in real estate and estate planning, which is unmarried couples buying property together. It seems to be happening more and more in practice. And some of these couples are planning to get married in the very near future, and some of them, quite honestly, have no intention whatsoever to be married, but they want to purchase property together. It might be a financial decision. They want to take things maybe one step further than roommates, but they don't want to get married. So there are some legal consequences to really going into business with someone without having a written agreement. So when married couples buy property together and then they sell property, that's easy to deal with the disposition of the asset. When married couples are divorced, a divorce might not be easy, but at least there's a divorce statute to follow. There's judges and lawyers and magistrates and mediators that are professionals that help follow a proper protocol to divide assets, to sell marital assets, and to split the proceeds. But and also, let me back up, likewise with business folks. When people go in business together and they decide then to sell a business asset, there's an operating agreement, there's a business deal, there's a plan, there's a blueprint that they can follow that spells out how the asset will be divided, how it will be sold, how one side might buy the other side out. That's all been decided up front. But what happens when unmarried couples buy properties together? It's sort of the wild, wild west. What's your experience, Candice?
That's absolutely correct. So unfortunately, our experience is everyone goes in on great terms and happy and excited to buy their first home. If things should go south, it's not so pretty when we're trying to deal with how do we handle now the sale of the property, one party buying the other property out? How do we account for things like who paid the down payment, who maybe handled the mortgage payments during the course of the relationship? What if there wasn't a complete even 50-50 split on everything during that process? And so that can be complicated. And the way that we like to advise people to sort of get ahead of that are really by 2 primary mechanisms. One would be a joint property ownership agreement between the parties. That's essentially a contract between the parties that outlines all the things we just mentioned. How our expenses are going to be handled while we're together. What if we were to break up? What if one of us were to pass away? The other tool that we often use, and ideally you use these together, would be a trust, a revocable trust. So that can help us keep things out of probate in the event that someone should pass away. And then if it's a couple who is contemplating marriage, a prenuptial agreement. So historically, prenuptial agreements were something that were used for high net worth clients, and that's just not the case anymore. With people getting married later in life, often they're coming to the relationship with assets already in place, and so a prenuptial agreement does not have to be overly complicated. It can simply address, as you said, Jackie, the disposition of assets if things should go south.
So I had an example in practice where a young couple, unmarried, purchased property together. The lady in the relationship actually brought about $40,000 to closing, and the gentleman didn't bring any funds to the closing. Well, they broke up about 18 months later, and they decided to sell the property, and she wanted her $40,000 back off the top of the proceeds and then split the remainder. But the deed was vested as joint tenants with rights of survivorship. And that means he had the right to an absolute 50% share of those sale proceeds. He had the legal right to that. It didn't matter that she brought the $40,000 investment to the closing table. That her investment was not protected. She could have protected that investment by just scheduling a consultation with someone like Candice to draft a very simple and basic agreement that isn't expensive, really, when it comes to legal fees. This is probably one of the more simple and least time-consuming in terms of legal billable hours that we would probably contemplate in our practice. So it's simple and straightforward, but it's a step that not everyone is willing to take. And you know what? It's not always just the money that they're looking to save. It's an uncomfortable conversation to have. I think people come to these relationships sort of with stars in their eyes about, the romance of home ownership, not thinking it through as really the business transaction that it is. So what we recommend in this instance, if you are looking to purchase property with another individual, no matter what your relationship is, give us a call. Candice would be more than pleased to have a complimentary consultation with you. This is important when you're contemplating the purchase of real estate and really combining that with some estate planning. And our practice can accommodate that. So we're a real estate practice and we serve estate planning clientele. So it's real estate and estate planning, and where those two things converge, it's real planning, and we can assist you.